In California law, Health and Safety Code section 11379.6 makes it a felony to manufacture, compound, produce, or process any illegal narcotics. Now, the most common example, and the one we always think of, is somebody operating a meth lab. And certainly that's an example of manufacturing narcotics. But really, anytime you alter the chemical nature of the drug, you could be charged with this offense. For example, if you are processing powder cocaine to make it rock cocaine, you could be charged with manufacturing. Or another situation where we see this often come up is when people bake ketamine and either use it or sell it as a powder to be snorted. And if somebody gets caught in that process, then they could be charged with manufacturing.
In California, if you are convicted of manufacturing narcotics, you are facing a maximum penalty of up to 7 years in state prison. Additionally, the penalties could be made even more severe if there were children present when you were manufacturing the narcotics, if you were manufacturing a large quantity, or if your production caused another person to suffer great bodily injury or death, or if you had certain prior drug convictions.
As serious as this crime is, we at the Shouse Law Group know that a lot of innocent people get wrongly accused and wrongly convicted. Fortunately, we have a great record of success in getting manufacturing charges reduced or even dismissed.
One common defense in a manufacturing of narcotics case is that your actions were merely preparatory. So, for example, you may have gone out and collected certain ingredients that are precursors to make methamphetamine, such as ephedrine. And all of these items are legal in themselves. And maybe they're in your garage and the police raid your house and they find them. Well, the fact is you had not yet begun the process of manufacturing. It was still mere preparation. So in a situation like that, we should be able to defeat the charge.
In order to be convicted of manufacturing narcotics, the prosecution must prove that you had some sort of participation in the production. You may have been hanging out with people who were producing drugs, but you were just hanging out. You weren't in on it. If we can show that you were merely present and not actually participating in the manufacturing of the narcotics, then we should be able to get your case dismissed.
Another defense to a manufacturing of narcotics charge is that the police violated your rights in obtaining evidence against you. Even if there is a warrant, we often find that that warrant may be defective. If we can substantiate that the warrant is defective in court, there may be a way for us to get your charges significantly reduced, if not dismissed.